Okay, so just now we've got the recording started. So again, just to say, we've got Teresa Hughes from the CPS, who's going to be giving a little bit of an overview of the role of the CPS, and there's going to be an opportunity for questions and discussion afterwards. So over to you, Teresa.
Okay, thank you. I hope you can all hear me. Someone shout up if you can't hear anything at any point, because I can't see anything except my presentation. So I'm Teresa Hughes. I'm a lawyer at the CPS. I've worked here for over 32 years. That, like many things, wasn't really my life plan, but that's the way it's turned out. I've done all sorts of roles within that. Started off prosecuting cases in the magistrates' court. That includes, doing trials as well as presenting cases for guilty pleas, cases that you're listing for trial, that kind of thing. Then worked in the Crown Court unit for quite a long time. That involves more serious crime, including homicides, fatal road traffic collisions, some hate crime, drugs operations, really everything that's not very, very complex, which goes to our complex case threat unit. And then up until a couple of years ago, I worked in the RASO unit, which is rape and serious sexual offences and child abuse. Did that for some time. And then for the last year and a half, I've been in this current role, which is sort of more varied, more engagement with communities, more sort of looking at policy and things, looking at analysing, our performance. And the particular areas that I work in are hate crime and domestic abuse, really. And I've also been doing quite a lot of work with our communications with victims and that kind of thing, the letters we write to people when we are not proceeding with cases. So that's a bit about my current role. I've met Leah because she's agreed to come on my first ever disability scrutiny panel, and was a great asset to that, and I'll talk a bit more about the panels as we go on. But I'll just explain from the outset sort of, who we are and what we do. Some of it, I'm sorry, I don't mean to insult anyone's intelligence. I'm sure some of you know this, but some of you might not be entirely clear. So I'll just go through that briefly, and then there should be some time afterwards to have more of a general discussion. So this is our role, really. We're the prosecutors, not the investigators. So we advise the police on cases for possible prosecution. They submit the case to us and we review it. We determine what the charges should be in pretty much all the cases, except very minor cases that they can charge themselves. They're not supposed to charge hate crimes themselves, so all hate crime cases should come to us. It's all electronic these days. They submit a digital file to us with the witness evidence, a summary of what's happened, any what we call unused material, but the logs, the things that are not actually witness statements, but evidentially interesting usually, any exhibits, any photographs, any video recordings. There's more and more of that these days with hate crimes, sort of ring doorbell footage and that kind of thing, CCTV. And then we look at the case and we decide whether there is enough evidence for any charges and whether we should be taking the matter to court. And I'll come back to a bit more detail about what we actually look at. We then prepare and present the cases in court. So in the magistrates' court, that's generally our CPS staff, our lawyers like me, sometimes associate prosecutors who are not fully legally qualified. They present some of the more minor cases. Lawyers generally deal with the trials and the prosecution in the magistrates' court. In the Crown Court, again, we have some of our own lawyers, but often we instruct counsel, so barristers really from different chambers. The work's just shared out between them really locally, and most of them do some defence work and some prosecution work. And then as part of our role, we obviously provide information and assistance and support to victims and prosecution witnesses in terms of their whole passage through court, really, from when when we're looking at the case to start with, to if they have to attend court as a witness. So we're governed by the Code for Crown Prosecutors, and we have a two-stage test. So the evidential test is whether there's enough evidence against the defendant for a realistic prospect of conviction, which means really, would they be more likely than not to find them guilty? So not to be confused with the legal burden of proof. We're not looking at that as our test. We're not saying we have to be sure that they're going to be convicted by a court. But our test is a less than that, really, but it's looking at whether this is something we should be taking to court, and then the court, will be able to look at the burden of proof and see if they are found guilty. We have to pass the evidential test before we can go on to the public interest test. If the evidential test isn't met, it doesn't matter how high the public interest is. We can't do that. We can't proceed to that. And as it says in this slide, if it's a hate crime, then it's very likely that the public interest test will be met. If it's motivated by any form of prejudice against their actual or presumed ethnic or national origin, gender, disability, age, religion or belief, sexual orientation, gender identity, either hostility directly towards the victim or any of those characteristics, or people in that position more generally, then the chances are we will proceed with it and the public interest test will be met. If I could give you a small example, the only time when it might be is if we've got somebody who isn't really able to come to court. So somebody maybe that's very ill or very, very old, something like that. But it would be those extreme personal circumstances probably relating to the suspect, which would mean the public interest test wasn't met, or on occasion someone that's serving another sentence for something else and a lengthy one. So those are the kind of things. There's all sorts of factors that look into the public interest test, but generally in any kind of hate crime, we would be looking to proceed with the case. So these are just a few national facts and figures to give you just some rough idea. We can only use published data now, so I'm sorry it goes back as far as March. I think on the CPS website now it might be a bit more recent, but the numbers don't change that much really. That's the number of hate crime referrals here, 3,060 in a 3-month period compared to, you can see how much there is for all crime there. And you can see the vast majority of those cases are complaints about racial abuse frequently. Some religious, low numbers, although I think they're always a bit lower than they should be, because there is sometimes it's mixed abuse, it's racial and religious. Sometimes people are not really honing down on whether it's actually religious abuse rather than racial. They're sort of treating the ethnicity and the religion as one when they shouldn't be. So I think the numbers for religion should really be higher. Higher numbers maybe than you'd expect for homophobic abuse, but some of that is abuse, as is some of the racial abuse, is abuse labelled at police officers on arrest by suspects when they just come out with a whole stream of insults, and racial and homophobic ones are very popular ones within that stream of abuse. Disability and transphobic, as you can see, the numbers, and these are national figures here, are really horribly low, and this is something we're all trying to work on to improve the number of those cases that go through the court successfully. What you can see here is the conviction rate for hate crime is really high. So if we get it to court, we generally get a good result. And if we don't get a good result, it's often because somebody hasn't come to court as a witness when we're expecting them to, or something similar to that. But if we do proceed with the case, we're often successful. So other work we do with the police and other agencies to try and improve referrals are scrutiny panels. So we have a hate crime scrutiny panel where we have people from a number of charities that deal with victims of hate crime. We have people from local authorities, sort of safeguarding and housing, really anybody that expresses an interest and applies to come on the panel and represents an organisation that's active within hate crime is welcome to apply. And we hold these panels at the moment quarterly. In addition to that, as I mentioned at the outset, we're now doing a separate disability hate crime panel because that's an area where the numbers, as you can see there, are particularly low. So we're doing that twice a year at the moment, with another one coming up shortly. Less people involved, but a sort of more intense discussion about how we can improve our performance in that area. One of the messages we've been trying to get the police very much recently is to sort of encourage them that just because a case is, and we don't use this expression very often, but you'll all know what I mean, which is why I'm using it, word against word, that's not a bar to prosecution. If there's no reason to doubt the account of the victim, then we should be looking at proceeding with that case. If we've got a credible victim talking about an incident where there's no reason to doubt that happened, just because the suspect unsurprisingly says, I didn't do that, doesn't mean we shouldn't be proceeding. Police are doing this partly with us in terms of more referrals to us, but they're also looking at taking on that mindset really for cases where they deal with them by what's called an out-of-court disposal. This is sometimes a caution, a conditional caution, some kind of work in the community where they're given some kind of education or restorative justice practice. And that can be very effective. It can be much more immediate than a criminal prosecution is. And it can work around, their education really, in terms of, they will be asked to explain why they think what they've said is okay, and they'll be put right on that, in short, really. So a lot of work going on there with all the forces that we work with to try and really pick up some of these sort of less serious crimes. They're serious to the victims, but they're less serious in the scale of what kind of penalty you can get, and try and get a more positive outcome for them, whether that's an out-of-court disposal or whether that's a prosecution. So what we need to know, as I said, the police are the investigators, and then we're the prosecutors. So we need from the police the evidence, and they provide that, as I said, in the form of statements, sometimes a video recorded interview with the complainant, statements from witnesses, statements from the victim, CCTV sometimes, both people's personal CCTV and town centre CCTV, footage from things like ring doorbells, footage from people's mobile phones, the evidence from the officers that attend at the scene, what they see, what they hear. And what we need as these just simple questions, really: what happened? Where did it happen? When did it happen? Who was there at the time? Who did what? So sometimes we might, for instance, have some CCTV evidence sent to us, but we also need somebody to tell us what's on that. We don't know who the people are. We don't even know where it is. So it needs to come with some explanation. So normally that would go hand in hand with a witness statement to put the two together, really. So we've got a witness explaining who they are and what's happened, and then we've got some CCTV where we can see what happened. What we also really need are specifics. Who said what actual words were used, how often were they said, what tone were they said in, how did that make the victim feel, why did the victim think that was a hate crime, did they actually say something overtly to them, or did they just perceive that was happening to them because of one of their characteristics? So that kind of thing needs to be as clear as possible. And as I said in the end of the slide, be as specific and detailed as possible. We need to know more than sort of general phrases like "he racially abused me." It's difficult to proceed with the prosecution on that basis. We need to know who said that, how they said that, and what actual words were used. Obviously, as I look at cases that we've reviewed, there's some very obvious racial slurs and offensive language that we all agree is offensive. But sometimes it's not quite as straightforward as that. And if it's not, then it needs to be explained. But some of the more obvious words that are clearly unacceptable to use these days, they don't really need to be explained. And, the lawyer reviewing that will see the words that are used and realise that, the test is probably met to proceed with the case. So what we can do to help victims and witnesses in these cases are something called special measures. A bit of a strange phrase, I think, when you're looking at it from the outside, but it's something to help the witness when they come to court to give evidence. And there's a range of things that are available. They're not available to every witness in every case, but they probably will be available in a lot of hate crime cases. So screens generally mean that the victim or witness cannot see the suspect or defendant. So they cannot see who they're giving evidence against, but they can see, the judge, the jury, and the people that are asking them questions. Evidence in private, that isn't something that happens very often, but it's as a possibility. In relation to people that might not feel comfortable in a courtroom where judges and barristers have got wigs and gowns on, then they can ask to be removed. That's often more likely to be used in cases involving children, really. So it's a less intimidating and a bit more of a relaxed setting. Video recorded interview. So this is something that is really quite helpful rather than a written statement. This is available for children and it's available for vulnerable witnesses. And vulnerable witnesses are identified as witnesses whose quality of evidence is likely to diminish because they either have a mental disorder that can include a number of kinds of mental illness, a significant impairment of intelligence and social functioning, or a physical disability or some kind of physical disorder. So it's really designed to help anybody who may struggle to give evidence in the usual straightforward way in the witness box. I hope that makes sense, and that's something I can certainly answer some more questions on. There's also some circumstances for intimidated witnesses. It doesn't apply to everybody. Again, there's various scenarios, but really it applies to sort of violent offences, domestic abuse cases, where again we can ask for some of these measures. In some cases, we can take pre-trial video recorded cross-examination. So that's what's called the Section 28 procedure. So that means both the initial account is taken on a video, and then the cross-examination takes place sometime before the trial. It's dealt with as a sort of separate hearing, and often the questions are discussed in advance for something like that. It's often used for children because obviously, you know, they're younger, their memories are not always great, and it's very much in their interest that they give their evidence and they get asked questions about that as early in the court process as possible. But it can also be used as a tool with vulnerable witnesses. Again, you know, for instance, if there was a health deterioration or something like that, so it would be better to get their answers while they're able to. That's something that could be considered. Communication aids just means all the things you'd expect that to mean, you know, hearing loops and other things like that. And then something that is and can be important in cases involving somebody with a disability, an intermediary. The purpose of the intermediary is not to explain the questions, really. That's what the lawyers asking them should be doing. It's to assist with communication for those with mental or physical disabilities, including hearing and speech difficulties. So it's to sort of make sure they understand the question and allow them to give their answer by making sure the question's put in such a way that it's within their ability to answer it. I know that's a bit complicated, but I hope it makes a bit of sense. It's not really a second person to explain what the lawyer means who's answering the question. It's maybe help the lawyer understand the need to put the question in a different way. But it can certainly be a useful tool, especially for somebody with B up there, the impairment of intelligence and social functioning, somebody that isn't able really to give very structured or very detailed answers. The intermediary can help with an assessment, and then the discussion and their attendance in court to try and make sure that we get as much as we can from the witness and we're not missing out simply because we've not found the right way of doing it. So in terms of witnesses coming to court, witness care officers are employed by the police, but a bit of a separate unit. They give out the information about what's happening throughout the lifespan of the case, and they also take information from the victim witness and or their carers in terms of, you know, getting them to court, whether they need an interpreter, what they think they might need, and then that information should come to us. And if, for instance, somebody thinks an intermediary is needed, either the police or you know, through the witness care officer, then that's something we will look at applying for. And then we've got citizens advice who deliver the witness service at court, which just means in short, there's some people at court looking after the people that attend. So in terms of getting it right and giving the best service we can for victims and witnesses, which is what's really crucial for us, especially in cases where anybody, for instance, has some kind of disability or might need an interpreter or something like that, that there's early discussions, detailed information from the outset about what they need to allow us to make that application for special measures with input from, you know, family members, support services, carers, as to, you know, what we can do to A, get the best evidence from the witness in the first place, and B, if they need to come to court, you know, manage that process properly. So where does the prosecution process go wrong? This is obviously then for victims and witnesses, but more generally in hate crime cases, it's where we've not got enough detail in the statements about what happened and the impact it had on the victim. So the officers taking the statements, and there's lots and lots of officers, certainly in the areas I work in, they're new to the police force, they're not ever so experienced. And so it's trying to make sure that the message goes all the way through everybody that's here today and everybody else, that the more detail we get at the outset, the better chance we've got. We struggle with witnesses not being kept up to date, victims not being kept up to date. There's huge delays still in the system from, the time of COVID when the courts were shut. Trials are triple listed, sometimes quadruple listed, and then they go off and they go off. And although hate crimes are high priority, so cases where somebody's in custody, domestic abuse cases and things. So lots of things are a high priority, and the chances are you're in a queue with other cases that are also a high priority. So, people lose interest, understandably, as the case proceeds through the court system. Which is the last bit there, witness attrition, really. People move away, so they move away from the problem sometimes. Lots of hate crimes involve neighbour disputes. They move jobs. Sometimes we've got cases where people are, for instance, delivery drivers or picking up at particular restaurants, and they've got problems with particular individuals there, but they change their job. They just don't want the case hanging over them any longer. It's not always an easy experience being a witness at court. And so people just, after a certain amount of delay, think that they'd rather not have that anxiety about the proceedings, even if it means that the suspect is not then prosecuted. So finally, I think this is the last slide. So all cases prosecuted as a hate crime should have a sentencing uplift, which means the court should first decide on the appropriate sentence without the hate crime element. This applies even when we're charging as a hate crime specific offence. So, for instance, a racially aggravated assault. They should still think about the sentence, and then they should decide on the sentence and then apply an uplift. So, for instance, if it merits custody, the sentence should be enhanced by a bit more custody. If it's some unpaid work, for instance, again, some additional added on, and the first sentence and then the uplift should be announced. Generally, I think you're looking at 20 to 25% increase on whatever the sentence is. So if it was 100 hours unpaid work, it would probably be increased to something like 125. That's not exact science. Same 12 months in custody might then become 15 months in custody. If it's a community order, you might get a bit added onto all the bits of it, really. So you might get a slightly longer order. If you've got some particular sort of activity days in that, designed around education and things, you might get more of them. You might get more unpaid work as well. So you might get, a number of different add-ons there, really. An interesting example here that doesn't add up to that 25% rule is in any kind of homicide case or murder in particular, the starting point is 30 years rather than 15 years. That's a massive differential, isn't it? It's the same, for instance, if there's a sexual element in a murder case, again, the starting point is 30 rather than 15, and then their lawyer will argue, I think, reasons why that should be a bit less, and we'd probably argue reasons why that should be a bit more. But that is a minimum term in those cases. It's not subject to the reductions that other sentences are subject to, for instance, being released partway through and being released on license. It's a minimum term, so obviously 30 years is a long time. And again, just a final statistic here, really, that up to the 3 months up to the end of March of this year, we got an uplift in 77.5% of the cases. So pretty much we should get an uplift if we prosecuted as a hate crime and it's gone through the trial or process, or as a guilty plea as a hate crime, then the court should be imposing an uplift. When they don't, it's sometimes because somebody's forgotten to ask. That's either external counsel or our staff, or because, for instance, in offences that are actually a racially aggravated offence in the first place, the judge might take the view that that's already really incorporated into it. Or sometimes it's the case when the hate crime is not the only offence they're prosecuted for, and they might be prosecuted for some other cases that carry a bigger sentence. So they use the sort of totality principle now in terms of sentencing. So sometimes they'll put all the sentence really, or most of the sentence on that more serious crime. And the hate crime case will have a sentence, but it won't be uplifted because, for instance, they might get 12 months imprisonment for the hate crime, but they might get 5 years for something else, and that 5 years isn't a hate crime. I hope that makes a little bit of sense. I'm going to try and stop sharing now. Hopefully that'll work. And
thank you. Let me stop recording.